A massive setback today for the hijab petitioners. The Karnataka High Court has upheld the ban on Muslim girls wearing the headscarf inside the campus. My colleague Akshita Nandagopal has spoken now exclusively to Bengaluru's Member of Parliament Tejasvi Surya. Listen in to what the MP has to say on this ongoing issue.
Tejasvi Surya, BJP MP and Chief of the BJP Yuva Morcha is joining us on this broadcast. Tejasvi, namaskara. I want to understand from you what your view is on the Karnataka High Court order and also largely on this entire hijab controversy, which I'm sure you've been tracking very closely as well.
Namaste, Akshita. The High Court of Karnataka has today pronounced a very detailed order after having considered all sides to the argument, after having heard petitioners as well as the respondent and all points of view that were placed before the High Court. The High Court of Karnataka, in my humble opinion, has rightly pointed out that the practice of hijab is more of a cultural practice than an essential religious practice in Islam, and therefore it does not fulfill the test of the essential practice requirement. And it has also said that the protection offered under the Constitution under Article 25 is subject to reasonable restrictions, and the state has the authority and the constitutional right to impose these reasonable restrictions under Article 25 as well as prescribe reasonable restrictions under Article 19, and in that sense has upheld the state's power to prescribe a uniform. It has also dismissed the petitions and in that sense made it very clear that those who are arguing that hijab is essential for Muslim girls to over and above kitab, that argument is flawed. I would say that this is a very important judgment because this judgment further strengthens the educational opportunities, educational rights of girl children, especially those children belonging to the Muslim community. A section of the Muslim community made an attempt to reverse the progress that was made by the Muslim women to procure for themselves education and equal rights. By this judgment, the High Court has protected all those interests of all those Muslim women who say that hijab is not our fundamental, is not being imposed, is being imposed on us, that hijab is not an essential practice of our religion, that we want to embrace modernity, that we want to embrace mainstreaming, we want to pursue educational opportunities like any other young girl from a different section of society. In that sense, I would welcome this judgment.
You know, in the reactions that have come in, one is of AIMIM Chief Asaduddin Owaisi, and many others have voiced this view, particularly in the last point that you mentioned about education of Muslim girls, that this could actually deter it in the sense that girls who want to wear the hijab will no longer go to class. We're already seeing some incidents of boycott. The petitioners have said we're not going to attend classes till we can wear the hijab. There's the other circumstance of, you know, parents saying we won't send our girls to school if they can't wear a headscarf, if they can't wear the hijab. How do you counter that?
Well, the judgment itself points out that this entire controversy erupted at a particular time that is a very recent vintage, as recent as December 2021. So this is not like, this practice was followed in all these particular schools from the last few hundred or thousand years, and this was being proscribed recently. So that is a point, that a factual point that the High Court also has observed in its judgment. Having said that, if a Muslim family or a person feels that they want to go to a school which has this particular type of uniform, that is a hijab or a burqa or that kind of a uniform, and they want to follow that particular, they want to wear that for their uniform, then there are many institutions that are available which they can go to. Article 30 gives protection to minorities to set up educational institutions where they can set up rules, prescribe rules, which specifically can be aimed at protecting the culture of a particular minority.
So you're essentially
Therefore,
saying if a student wants to wear a hijab, they should go to one particular kind of institution.
What essentially the High Court has said is that institutional rights in a qualified public space like a school will be prioritized over an individual's right. Therefore, if it is a school which is, say, governed by the state, which will have a certain rules for uniform that will be prescribed by the state, then those people, those children who submit to that school, who enroll themselves in that school, must essentially place their institutional interest over and above the individual choice of that particular children. In the same way, if a particular child would want to go to a school which is, say, administered primarily by the minorities, for the minorities, then it is a different matter. In this case, however, the High Court has very specifically mentioned that the interest of the institution is paramount and the institutional rights is over and above the right of a particular individual when a particular individual joins a school,
but the question
which is a qualified public space.
The question that arises is that at the end of the day, are we going to be seeing a negative impact on the ground of Muslim girl students being pulled out of their schools? The other aspect to this, Tejasvi, which has been raised time and again, is that this is an infringement of a woman's right, a basic right of choice, something that Mehbooba Mufti Omar Abdullah have said, that you're not allowing her to wear what she wishes beyond religion and all of that. A basic choice is being taken away.
Well, this certainly is a move towards reform. This is a move towards progress and modernity. There are a certain elements in society which do not want Muslim women to embrace modernity, embrace equality, and become a part of the mainstream of the society. It is these very Mehbooba Muftis, these very Omar Abdullahs who support the stand of rabid mullahs and terrorists. These are the very forces which opposed the liberation of Muslim women from triple talaq. These are the very forces which opposed Muslim women from getting a right to maintenance